Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, I'm going to briefly discuss something called Presumption of Abandonment of United States Lawful Permanent Residents. This can occur in multiple different ways, and it's a fairly common question I get from some of my clients who are attempting to get green cards to the United States. Basically, the question is, well, how long does how long does my spouse have to remain in the United States to maintain their residence? This mostly comes up in the context of folks that, they either work offshore, they may be in the military, they may be a contractor for the United States government working overseas, they may just have various business endeavors occurring overseas, or they may sort of, split some of their time where they're living, say, here in Thailand, and then living a fair amount of time over in the United States. Everybody's situation is different. There's not going to be any one-size-fits-all sort of solution for everyone. But understanding residence and presumption thereof and presumption of abandonment basically can provide some insight into how this overall system is going to operate. The first thing to keep in mind is there sort of was a time when if one simply showed up once a year in the United States with their green card, everybody just kind of went along and said, yeah, you're still a lawful permanent resident. As can be seen in some of the literature provided by, say, the Department of Homeland Security and various other agencies associated with immigration, this is not actually the case. There is no hard and fast rule, i.e., a set number of days which must be spent in the United States in order to maintain residency. At the same time, there's something of a discretionary test that sort of goes on with respect to officers affiliated with, say, U.S. Customs and Border Protection, where basically they have to sort of ascertain whether or not they feel that that individual does indeed still maintain an intention to be a resident and is still a resident. One hard and fast rule with respect to presumption of abandonment of residence comes about with respect to green card expiration while one is overseas, or simple having been abroad for a significant period of time, where it's just pretty self-evident almost that residence has been abandoned. So, for example, I've had clients over the years who've gained lawful permanent residence at some point, and they've never naturalized. They've maintained their permanent residence, and they move abroad. And they may think at the time they're moving abroad that they're simply going to be away for 6 months or something. And then 6 years later rolls by, and they try to go back to the United States, and they may have I've actually seen this happen. They'll have an expired green card, and they simply think, well, I'll just go back to the U.S. and get a new green card once I'm there. No, it doesn't work that way. Once if you have an expired green card, it's very highly likely that the airlines won't let that individual on the plane even to go to the United States. The other thing to keep in mind with respect to that is, okay, you've been gone from the United States for 6 years. That's a long period of time that you haven't been physically in residence in the United States. It's a pretty fair bet that there's going to be a presumption of abandonment of residence under that situation. And probably, if there's an active green card in the matter, involved with the matter, that presumption is going to be raised by a Customs and Border Protection officer back in the United States. Again, if the green cards have gone ahead and expired, one probably isn't even going to be able to get on a plane to go back there. Something else to think about with respect to presumption of residence is the issue of so-called returning resident visas, which is discussed at length in another video on this channel, so I recommend checking that out. But with respect to presumption of residence, there is no hard and fast rule. But what I tell people is make no assumption that just touching U.S. soil once a year is enough to get one over the threshold of maintaining their residence. One really needs to have and be able to show genuine residential intent with respect to the United States. But that being said, if one spent 8 years in the U.S. and then 9 months out of one single given year, they just happen to be, let's say, abroad. They happen to go back to their home or their original home in Thailand, for example, or the Philippines or whatever. or there were some significant family issues or business issues that came up that require that individual to be abroad for a significant portion of a given year. Is it likely under that hypothetical scenario, you've got 6 years having been continuously resident in the United States, and then you've got this year where there was 3 months and 9 months where you weren't, and then you're trying to go back? As long as there's a valid green card in play in that situation, I don't think you're going to see any problems with a Customs and Border Protection officer, because it's fairly simple and it's fairly straightforward to explain the situation and explain how one's residential intent remained intact. Again, in matters where it's like, wow, you were abroad for years, nearly a decade, you know, how did your residential intent remain intact, and under what circumstances did all of this arise? There probably are very limited, narrow situations where perhaps there was a legitimate reason for what happened, and, you know, the presumption can be rebutted. But that being said, in most cases, it's a good idea to keep an eye, keep a clear eye, keep a good eye on the issue of presumption of residential abandonment, and do things in order to forestall or be able to rebut that presumption should it be raised.